What year?
84.
84. And Peter has been a great friend of the school over the years, very involved in supporting a whole variety of initiatives here at the school. He's also been a bencher for how many years now?
7.
7. And Peter might explain to you what a bencher is. It's so much
Yeah.
of a curious term to describe the governing body of the Law Society. And Peter has been very involved in the issue of licensing and the question of articling for a number of years in your role as a bencher, and chaired the committee that has put forth the questions of proposals. So very grateful for Peter coming back to Queens to talk to us today about the licensing process and hopefully a question that will generate a lot of discussion, that is, should we get rid of articling? And Lucy, I don't know if you wanted to say a few words, because this is also an event that is jointly sponsored with the LSS and the law school.
Sure, yeah, just I guess thanks for everyone for coming out. And at the end of the discussion today, we're going to be doing a poll, sort of about questions about the options, and we're hoping to submit the answers of those polls to the Law Society and the consultation report from Queens. So we're excited that you're all here, and please ask any questions you have, I'm sure, and hopefully get your feedback as well.
Great, thank you. So over to you, Peter.
Great. So thank you to everyone for coming out. I'm going to start by just talking for about 15 minutes, which I think will be more than enough to tell you everything you need to know about licensing. So just to start a little bit about the Law Society, to remind everyone, the Law Society regulates all the lawyers and paralegals in Ontario, and it's responsible for licensing, standards, discipline, and professional ethics, amongst other things. We have a board of governors that consists of 40 elected benchers from the legal community, 5 paralegal benchers, and 8 public representatives, and then a whole number of ex officio members. The head of the organization is called the treasurer, and I'm an elected bencher, which really means I'm a director, and I was elected in 2011, and I'm just finishing my 2nd term. And one of my responsibilities, fortunately or unfortunately, is proposals to change the licensing process. I'm also very involved in adjudication at the Law Society. So let me just remind everyone about what you already know about our current structure. So once you finish law school, you have to complete our licensing exams. Currently, there's a barrister exam and a solicitor exam. They're both 7 hours each. Once you do that, you have an obligation to complete what we call transitional training. For most of you, that's going to be 10-month articling period. For some of you, you may decide to do the law practice program at probably at Ryerson, which is a 4-month course and a 4-month work placement. And once you're done that, you get a license and you go into practice. The only little wrinkle to that system right now is we have the integrated practice curriculum at Lakehead, where you can do some of your, in fact, all of your transitional training during your 3rd year of law school. That's the current structure, and we put the law practice program and what's called the PPD in Ottawa in practice in 2012. And right now there's about 250 candidates going through the law practice program PPD. So I'm just going to go back and tell you a little bit about some ancient history. When I was called to the bar in 1986, in those days, once you finished law school, you did 12 months articling, and then you did a 6-month course called the bar admission course, which was really like going to school for 6 months. You got practical lectures for members of the bar, then you passed what were called the bar exams, and you got into practice, and it was a very lengthy process. We changed that in the 1990s. We got rid of the bar admission course, and we replaced it with the current exam structure. We also reduced the articling period to 10 months. And back in those days, the demand for articling placements was roughly the equivalent of the supply. There were sort of variations from year to year. When I was in law school in the early 80s, we went through a dramatic recession in Ontario, and there were some difficulties for some students getting articling jobs. But by and large, demand met supply, and just so you know, the supply of articling positions is growing very gradually at about 3%. And right now, there's about 1,900 articling positions. So in the early 2000s, that picture started to change, and it really started to change for three reasons. First, there has been an increase in the number of graduates from Canadian law schools because of increased enrollment. Secondly, there has been a large increase in the number of Canadians who have traveled abroad to go to law schools that offer programs that are tailored to the Ontario market. And if you went back to even 2011, when I was first elected as a bencher, at that point we just had Bond University and a couple of other places in England. Now, I think the last time I counted, there were 25 English law schools offering programs geared to Canadians. So we have a huge number of Canadians who are going abroad, mainly to England, and then coming back and trying to get into our licensing process. And the third thing that has made things different is we have a huge increase in the number of really truly international candidates from all over the world who want to come to Canada to practice law. And so those people are going to law schools in their place of origin, and they're coming through what we call the NCA process. This is the National Committee on Accreditation. We have a body that, for foreign trained candidates, accredits them so that they can enter into our licensing stream. So by the time I became a bencher in 2011, we had a gap between demand and supply that had grown to about 300 candidates a year. And that's what led us to introduce the law practice program at Ryerson and at the University of Ottawa in 2012. Let me just tell you about the current position or picture. So we have about 1,900 articling positions currently. We have, I think, roughly 1,700 or 1,750 graduates from Canadian law schools competing to fill those positions. We have a total of about 2,400 to 2,500 candidates who want to fill those positions. So we have a shortfall of up to 600 positions every year. About 30% of our candidates, or roughly 700 candidates, are coming from outside our domestic law schools. Up to roughly 40% of those candidates are returning Canadians, that is, Canadians who have gone abroad to study. So if you do the math, and you take the current number for 2018 for the law practice program at around 250, and then you add to that the articling positions that we have of about 1,900, that would give us about 2,150, which means that even with the law practice program, we still have about 250 to 350 candidates who are not able to meet our transitional training requirements and therefore can't get through our licensing process in any particular year. So that's kind of the big picture in terms of the numbers. We have other things going on as well that are causing us concerns. As the pressure has grown for there to be more articling positions, we have increasingly students who are prepared to work for free to find a position. And we have students who are being taken advantage of by unscrupulous employers. We have ongoing concerns about the consistency and validity of articling, which is, as you know, it's a fairly subjective process that's left basically in the hands of employers. We are very happy with the content of the law practice program that Ryerson is putting on for us, as well as the University of Ottawa. But those programs are very expensive, and they're currently being subsidized by the entire cohort in any particular year. The law practice program also tends to have a greater percentage of racialized candidates than the cohort as a whole. And of course, it's drawing a significant number of returning Canadians and international candidates who can't find articling positions. So we have continuing concerns about whether what we call the two-pathway process is really a fair process. And then finally, we know that not everyone who goes through the licensing process ends up actually practicing in private practice. Many people want to pass our licensing exams and get the license, but then they choose to go in-house, or they go into government, or they do something else that's not what we would say is a directly law-related job. So all of this is taking us to wanting to have an in-depth look at the licensing process, and to develop an option paper, which we finalized in the spring, and it went out for consultation. Some of you will have read it. It's the consultation period is open now until the end of October, and it's been shared with all of our stakeholders. And then what's going to happen is we'll gather up all the input. My committee will meet. We'll make some recommendations to the benchers as a whole, and then we'll have a debate and hopefully reach some decisions probably in December or January. So let me just run through very quickly the 4 options that we're considering. There's really only 3 that are worth talking about. So the first option is that we just stick with the status quo, which I don't think is probably going to be realistic given some of the pressures we're facing. The second option is sort of an enhancement on the status quo. We would keep articling and the law practice program. However, we would mandate minimum wage for work placements, and we would take some efforts. So this would be there would be some steps taken by the Law Society to weed out articling placements that we consider to be marginal in terms of quality level. The current proposal also would require you to complete your barrister and solicitor examination before you could start articling or transitional training. And finally, this option and the other 2 options that we're considering that I'll come to in a minute include a new skills examination that's designed to test certain practical skills in certain key areas like drafting, for example. The cost of that examination has to be factored into whatever we're doing. So option 2, as I've described it, would lead to a cost for licensing candidates of roughly around $7,000, and the current cost of the system is $4,710. So it's a significant increase for all of you. That's option 2. Option 3 is what I would describe as an American-style model, where, as you know, in the United States, they don't have transitional training. You pass your bar exams, your state bar exams, and you're good to go. So under this model, once you complete your barrister and solicitor examination, you would get a license. If you go to a firm of more than 6 lawyers, we're done with you. If you decide to go directly from being licensed into sole practice or into a firm with 6 lawyers or less, we would require you to take an additional course that at the moment is called a Practice Essentials course that would give you some assistance with certain basic practice management tools so that you could open your own practice. And you would have to do that within the first 18 months of practice. In addition, option 3 also requires the new skills exam, as I've already outlined. The cost of option 3 would vary between $4,200 to $6,500, including the new skills exam. Those candidates who go directly into sole practice or into a firm of 6 lawyers or less would obviously pay more because they'd have to pay for the new practice course, but they would be working at the time when they would have to take that course. The last option, option 4, is we'd get rid of articling, and obviously option 3, there would be no more articling. Option 4 would also involve the abolition of articling, and instead we would put everyone, all of you, through the law practice program, except it wouldn't have a work placement, and it would be 4 months, and it would be essentially much like the Ryerson program is now, with a combination of online learning and some face-to-face teaching, but it would be designed to teach practical skills for those going into practice. This model, option 4, is really designed to eliminate the unfairness of the current 2 pathways model, but the cost is quite significant. We estimate it right now at being about $11,000 once you include the new skills examination. So those are the 4 options we're considering. Just wanted to say, with respect to option 3, for those of you who are already thinking about your articling job and maybe going to one of the major firms, for example, we expect that if articling was abolished, the firms would replace it with a training contract after licensing. You know, as I'm sure everybody in the room knows, many of the law firms treat articling as an opportunity to look and take a look at candidates that they're thinking of, you know, employing permanently. Our best guess, and this is based on discussions with a lot of people in the legal community, is that if articling was abolished, the firms would simply replace articling with a post-licensing work contract that would be up to 1 year in duration, and then you would go from there just as you do right now. So for many of you, option 3 would probably require less adjustment than the other options. Those are the options we're considering. We've been tweaking articling since the early 2000s. You can see from what I told you about the stresses, particularly on the demand side, that it's a difficult situation for us because we have so many coming in that we can't control. The Law Society, as you probably know, has no direct regulatory authority over the law schools. We have no ability to control either the number of students coming out of Ontario or Canadian schools, and obviously we have no ability to control students who choose to go abroad. So it's put us in a very interesting position, and we're trying to manage our way through it. Thought I said I would talk for 15 minutes, might be a little longer than that. That's really all I have to say. Those are the options. I've kind of outlined the costs. I think the rest of this session is really so I can take questions.
Right, thanks. So one question is in terms of the...
Hopefully I can eat my pizza, the rest of my pizza, while we're...
In terms of relieving the stress and strain on the law society by virtue of this over-demand, right, for our organization, does the law society have any wherewithal or ability to limit those who take their law degrees from outside of the country, limit that access? In the sense that, you know, you could make it a prerequisite for membership in the organization, in the practice, that you would have had to take your degree from a Canadian law school.
I think the best I can say about that, without getting into a really, you know, theoretical discussion, is that the advice we've had, the legal advice we've had historically, is that that's not really open to us. That you know, we have I'm trying to remember what the statute, we have an Ontario statute called, I think it's the Fair Professions Act. And there are human rights considerations that come into play in terms of professionals coming from abroad. And I just know that in our field, as in the field of medicine, people have fought over a lengthy period of time to be able to ensure that, foreign trained professionals get the same rights as Canadian trained professionals. So I don't think it's a road we can really go down. Yes.
Okay, I have two questions. My first question is, why is Ryerson being allowed to open a law school
Yep.
if there's already so many law students?
So let me just, I think I was asked, because you're streaming this, just to repeat the question. The first question is, why is the Law Society allowing Ryerson to open a law school? And your second question?
My second question is that, like, so I'm from Winnipeg, for example, and I specifically chose Queens over Manitoba because I thought I'd have a better shot at getting jobs afterwards. But if somebody went to law school at, let's say, the University of Manitoba, and then they articles, and they're based on Ontario looking for jobs, and I'm competing with them, wouldn't they have a stronger chance of getting those jobs? So if nobody else in Canada reviews the articling requirement, when
Right.
Ontario students
So I think the second question was, if only Ontario removed articling, what would happen with students coming from other provinces? Sorry, the first question again was about Ryerson. So I think the easy answer is, first of all, our law society has, as I said at the outset, we have only limited jurisdiction in connection with law schools. I have to be careful because your dean's here. We don't have the ability to restrict entry, and it would probably be very unwise of us to restrict entry. Other organizations that have tried to restrict entry in the past have got it widely wrong. If you just think about, for example, the oversupply and undersupply we've had of teachers in this province in the last 20 or 30 years. But in addition, in Ontario, we have an access to justice problem. So it's very difficult for us to say there are too many lawyers coming onto the market. Ryerson's pitch, by the way, for a new law school was partly on the basis that it would have a kind of an innovative, different program than the other so-called traditional law schools, but also that it might capture some of those students who are currently going abroad. So, I'm not going to get into whether that's right or wrong, but we discussed it at my committee. The benchers as a whole discussed it, and ultimately we decided that we should approve Ryerson. It's, at the end of the day, it's really up to the government as to whether there should be a new law school in the province. All right, the second question I think was about if Ontario abolishes articling, what will happen in the rest of the country? And I think the sort of short answer is the rest of the country would likely have to follow. Ontario licenses about 50% of all the new lawyers coming into the Canadian legal market. So we have huge clout. And if we made a significant change like that, it would have a ricochet effect or an echo effect on the other provinces, and I suspect a number of them would have to follow. That having been said, I have talked to some of my colleagues in the other provinces, and they don't have the same problem that we have in Ontario. Again, of the foreign-trained law school graduates who are coming into Canada, I think about half or 60% of them are coming into Ontario. Yes?
Do you know how many vote numbers for students who go through the LPP compared to those who go through articling?
The question is, do I know the employment, this would be post-call, for LPP students as opposed to articling? So I can't quote you the exact numbers, although they are in some of the background papers that are on our Dialogue on Licensing webpage. But I think the answer is the higher back ratio at the moment is significantly lower, but it is improving. And I was just reading, actually, on the way down in the train, we do an analysis every year of articling and the law practice program. We do focus groups, we do exit surveys, we do surveys of articling and law practice program work placement principles, and then we gather all that up. We have a professional who's a sort of an academic in the education business who puts that all together for us in a report. And one of the things that he says is that the law practice program is starting to gain a little bit of momentum. We're seeing now some of the graduates from that program being hired at some of the major law firms, which is new this year.
So just to build on what as I was saying before about the foreign people coming in, what about, would it be possible to put a foreign trained person through an LPP-like program as a mandatory step, and then at that point there's no competition for jobs in terms of an articling position between an international person, an internationally trained person, and a Canadian trained person, for example? Can that possibly avoid some of the articling, the issues in terms of articling jobs, and then the competition that becomes for normal jobs, just like any employer or any profession?
Well, that is, in fact, what is happening right now with the law practice program. If you look at the people who are in the law practice program, I think roughly half of them are international candidates. And they're also coming, remember, you know, some of you will have friends that have gone to the UK. You're coming back usually from those programs at the wrong time of the year. You have to go through the NCA process. You normally, by the time you get spit out the other end, you're not at the same time of year as the rest of your cohort. So a lot of those candidates find it, for various reasons, difficult to find articling jobs, and a lot of them are taking the law practice program.
But how about like a mandatory, you have to do that, and then that removes all the competition from any argument?
You know, we are reluctant to kind of treat one group as distinct just because they come from outside the country. And we are also reluctant to create a barrier to entry. So we've kind of, I think we'd resist singling them out and saying we have to have a special road for you and another road for everybody else. Yes?
Just continuing that, surely I think we would all disagree that discriminating on the basis of immutable characteristics, eye color, hair color, etc., is on start. But here we're looking at the substance of what it is they're learning. So even those who come from Oxbridge, for instance, would still not have the same exposure to Canadian law, practice, civil procedure, etc., criminal procedure, as one might have from a Canadian law school. They'll be different. You still study English law principles, and you're at a very high level institution. But notwithstanding that, I imagine you might be able to discriminate positively, that is based on somebody's exposure to the law that they would be having to practice when they arrive in the jurisdiction.
You should look at some of the advertising material from some of the English law schools. They're advertising, you know, Canadian professors teaching Ontario law, and that's and remember they're teaching. All of you have by and large an undergraduate degree. In the United Kingdom, this law is a first degree, right? So it's very complicated, and you know the UK firms, sorry, the UK law schools come over here. They have job fairs. It can be very attractive to go over there, and I think sometimes candidates don't realize all the problems they're going to have when they try to come back. So it's a complicated set of variables. It's, you know.
Would there be any potential or foreseeable conflicts of interest in terms of placement for the LPP itself, in terms of how that's run or demand for the program? And then the second one would just be with regards to the LPP itself and the costs. What's the justification, perhaps, of having current students pay for the LPP as opposed to people who are already practicing?
So 2 questions. The first one was whether now that Ryerson's going to open a law school, if it does open a law school, will there be any conflicts involving the law practice program? And I think the second question was about the rationale for the entire cohort subsidizing the cost of the LPP. So those are good questions. So I think the first question, first of all, we've been assured by Ryerson that it will continue to operate the law practice program, which has been successful for that organization. And we've also been assured that there won't be any conflicts that will be created that will cause a problem as a result of the law school. Obviously, the law practice program, by the way, Ryerson is an outside provider that puts the course on for the Law Society. We have a contract with Ryerson. We can always change that contract or go to another provider if it's not working out. So we do have some control over the product. With respect to your second question about every time I speak to a group of students, I get this question. So to make it even more, to put it in financial terms, prior to the law practice program, you were all paying around $3,000 to go through our licensing process. Now you're paying $4,700, and that $1,700 is the cost that every candidate has to pay, is the cost of the law practice program. All I can tell you is that the profession has made a $1 million contribution to the cost of the law practice program. We have had discussions, endless discussions among the benchers as to whether that number should be increased. I personally am sympathetic to the thought that the profession should make its own contribution, but to date, it won't surprise you to learn that practicing lawyers haven't shown a lot of interest in contributing. So the other thing that is an issue, frankly, is the law practice program has not taken off quite as we hoped. We had hoped for 400 or 500 candidates taking it a year. It's been significantly less than that, and obviously that means the cost per candidate is higher. Bill.
Yeah, question about the second option, by requiring paid placements in the LPP and also weeding out some of the more inferior articling spots. This would obviously have the outcome of reducing the number of LPP spots, and articling spots, they won't magically increase. So just wondering if you could comment on that. And then the second question, the third option, I'm just wondering why it would still be so costly if the LPP were eliminated, given the high cost of the LPP.
Right.
Why the licensing fees are still so high under the third option.
So, I mean, your first question, I think, sorry, just remind me again.
The first question would be that the number of LPP spots will reduce rather significantly if you have to require paid placement, or at least I'm assuming that. Likewise, the number of available articling spots will be reduced if you start weeding out the more inferior or problematic articling positions. So you just might be increasing the problem. I think the easiest way to deal with that is to say some of us in the know are well aware that that is a flaw with the second option. Is that so? What it will likely mean, and I actually think nobody's asked me this yet, but I think option 2 is probably the option that's favored by the benchers at the moment. But what it will mean is once we impose a minimum wage, it will mean that there will be a certain number of marginal articling positions that will vanish. And I can't tell you what that number is going to look like. It might be 25, it might be 50, it might be 75. We just have no idea. I think we have less concern about the law practice program positions because they're 4 months long, and that process is really run by Ryerson, whereas with the articling process generally it's self-run by the firms themselves. But there is a likelihood that once we start imposing additional parameters to protect you, it will reduce the articling pool slightly, and again, we just don't know how big that will be. Sorry, remind me now of your second question, Bill. The second one is, why is the fair not so costly. when
So,
you get rid of the LP.
Yeah, I mean, that I think is an easier, the reason the third option still costs a significant amount of money is the introduction of the new skills examination. So I don't have the numbers on the top of my head, but it's like $2,500 or $2,700 for that alone. Yes.
If the law society was to get rid of argument and the LPP to just sort of have an examination-based model, like what's, I guess the question is like, what is the jurisdiction of the law society, or how much do you think law schools would be forced to change parts of their curriculum so that becomes more practice or clinically based? Because right now, it's a lot of my friends, and they feel like if they skipped argument, they just wouldn't be prepared for practice.
Right.
So is that something that law society has control over, or what do you think would happen to that?
So the question is, if we go to option 3 and we go to an American-style exam model, will that create some pressure for law schools to offer additional, let's say, skills programs or practice, clinical programs? Again, it's a kind of a complicated question. I mean, the first response to your question is, in the United States, they have no transitional training. Lawyers manage to practice there. They go through the bar exams, they go straight into practice. They don't appear to have any problems. They don't have a higher degree incidence of negligence or errors and omissions problems in the United States. They turn out just as good lawyers as we do here. So I actually think that if we went to that kind of a system, people would adapt. But another factor in this is that, we now have a number of law schools operating slightly different models than the others. We have the Lakehead model. Ryerson is promising that it'll operate something slightly different. Clinical programs at law schools are expensive, and they take a lot of resources. There's a number of reasons why law schools don't offer more of those programs. And they range from sort of, big questions about, what is law school teaching about, to practical questions about, cost and just finding the resources. So I don't really know the answer to that question, but I don't think you should be concerned that if we went to an American-style model, lawyers would have difficulty going into practice. Part of the reason we've included this Practice Essentials course is that for somebody who goes straight out and wants to be in sole practice, we know they need some supports. And this is what we're really talking about, giving them the tools they need to be able to practice successfully on their own. Yes? So we're talking two different courses, right? We're talking about the skills course. So this would be, and it wouldn't be a course, it would be an examination. So both models 2 through 4 all at the moment require a new skills examination in addition to the barrister and solicitor examination. And that's the examination that would cost a significant amount to put on. I mean, the view of a number of my colleagues is that we should be testing for certain skills as well as content. So things like drafting, putting together an affidavit, certain types of skills that are not currently tested in the barrister and solicitor exams. I can tell you the whole idea of a skills examination is a little controversial. I'm not one of the people who thinks it's necessary, but I have a number of colleagues at the venture table who think very strongly that we need something additional. Yes? So the question is, do I have any estimate of the timeline? and when would we roll this out? So first of all, this is unlikely to come before convocation before December or January. If we, regardless of what we do, the rollout period is probably going to be anywhere from 18 months to 2.5 years, something in that neighborhood. So for those of you who are in, let's say, second or third year, you might in fact be able to get through the entire process without any change. For those of you who are in first year, it's more likely to hit you because I think we'd be rolling it out just when you're coming out. That led to some hands going up.
Question about the market's ability to absorb new school graduates. So if this is what's rolled out after associate with graduate, when we have to meet with the graduates from the first year students, we go with third model in terms of getting a first year associate job.
So the question is, if we went to option 3, for example, would we have a double cohort problem? We would have a double cohort problem, but we have gone through similar changes like this in the past, and I'm just trying to remember exactly when, but when we made some changes about 10 years ago, we went through a similar double cohort problem, and we managed to get through it without any great difficulties. But there would be a transitional process. There would be a transitional issue, obviously. I saw another hand over here.
Clarify, this written skill exam, it's not the bar exam, obviously.
No, it would be a new exam, and it would attempt to assess you for certain practical skills. You would probably have to study. You couldn't just take it on the fly. We expect that there would be providers that would be out there seeking to assist you to make sure that you had the training necessary to take it. Again, it's something that a number of my colleagues think that we're missing in the current barrister and solicitor exam. Yes?
Just confirming if this written skills exam is going to be in addition to the written content-based exam that exists already?
Correct.
Okay, and how closely would they have to be written?
I don't think we've decided that yet.
That's the question.
Yes?
So it seems now that first and the second option isn't really an option anymore. But if we were to go with the LPP mandate for all students, would that be done exclusively in Ryerson and Ottawa, or would different law schools have their own LPP?
So the question is whether, if we went with option 4, whether everyone would have to go to Ryerson or Ottawa. I think our anticipation is that if we were putting over 2,000 candidates through the law practice program a year, we would need additional providers, and we assume that some of the other universities and other centers would step forward. Yes?
What is your personal opinion on this?
It's complicated. Sometimes when I became elected as a bencher, I realized that, being a kind of a politician, you suddenly, there are only second best solutions. You have to make the best of what you have. So as Bill knows, I'm not a strong proponent of articling. I think it's kind of outlived its day. But the problem really is it's tried and true. The profession is used to it. For you, it does provide some real opportunities, and it also gives you a head start on maybe a permanent job. So there are lots of reasons why my colleagues think that articling should be retained. The option I actually like the most is making all of you go through the law practice program or a variation of it, but it's expensive, and you know, your fees would be going from $4,700 to $10,000 or $11,000. And I know all of you are already in debt from going to law school and from undergraduate. So, you know, we're very cognizant of that. The American style, just pass the bar exams and go, I just not sure that it's politically going to be saleable. There's a very strong tradition here in the province and in Canada that, you know, we like to have transitional training to make that, you know, leap from law school to practice. And I think most practicing lawyers feel that we have a better system than they have in the United States, and they want to keep it. So, you know, even it's a kind of an elegant solution in some ways, because it really, for the regulator, it allows us to focus on kind of regulatory risk, and our regulatory risk is almost entirely in small firms. It's you know, those of you who end up in government or in large law firms, we don't have any really real regulatory problems with you. Our problems are with sole practitioners and people who get into financial difficulties and who perhaps don't have the right training. So that would allow us, option 3 allows us to focus our resources on that. But I am a little skeptical as to whether that's going to be saleable to the broader legal community. So, yes.
I think it's the original finances, because a lot of them line of credits. So line of credits, they're written where you have a 1-year grace period where you're supposed to start auditing. After you're supposed to start paying it back, now if you have to go back to school, is that a consideration that we're taking into account?
I mean, it is something we could potentially take into account. I've had questions, you know, right now the law practice program I don't think is eligible for OSAP. There are things like that that are mechanical details that we'd have to work out in any new proposal. You know, I wanted to put the numbers on the table because I did an event like this a couple of weeks ago at U of T, and students were asking about the math and about the dollars. The benchers are also well aware of the costs for you and the fact that these are significant. Some of these numbers are quite significant. So, you know, hopefully that'll all be taken into account in what we decide to do. I've got, okay.
So would most law schools end up offering the LPP program, or would it still only be at like 2 schools? Because then, back to the cost thing, we would have to move to another city that you may have no plans of ever passing in for at least 4 months. So it would actually end up costing us a lot more than the figures you're giving.
I mean, look, I can't be categorical, but I think it's likely that the major centers we would find a university. It doesn't necessarily have to be a university that has a law school. The law practice program right now is offered at Ryerson. Ryerson doesn't have a law school at the moment, but our expectation is that if we were going to do something like that, we would try to find a number of major centers, but it wouldn't be everywhere, obviously. It might be 3 or 4 locations. Yes.
Something that can mitigate in favor of doing away with articles. If I told everything will come down to the numbers, and you would know this better than I would, be the negative impact of articling on Canadians who are Canadian lawyers who go abroad to work in international organizations, as I did at the United Nations. And what do I mean? Human resources in these organizations asks for certain years of experience. Yet when they come up with a student at law period of time, they don't know what to make of it. So when competing against American lawyers, for instance, at the United Nations, who can very clearly detail when they graduated, how many years of practice experience they have, Canadian lawyers are at a disadvantage. Of course, everything will come down to the numbers. How many graduates and members of the Law Society of Ontario go abroad to do practice of that sort? I liken it with the shift from the LLB to the JD designation. Canadians were equally disadvantaged in the market abroad by virtue of the LLB. And so if that could be done, perhaps this is something you might use with your colleagues to argue, hey, look, get rid of articles for the following reasons, because it impacts us internationally, and yes, Canadians matter internationally. There's that. And also, the matter of the profession bearing the costs of this, I think needs to be carefully looked into. I mean, I understand $1 million is given, but I don't know whether or not it's possible for the Law Society legally to collect money from perhaps the profession and build a fund that carries itself over time, right? From which the Law Society can draw to pay for these costs that would then defray the costs of the LPP or LPP as it is from the students. Always go for deep pockets, and the students aren't clearly the deep pockets. The deep pockets are in the profession. That's me. And in order to defray those costs, put it into a fund and let the fund carry it itself.
Well, I think all I can say is I'm personally very sympathetic. The argument on the other side that I hear all the time is, you know, students are going to be entering a profession that generally tends to be financially rewarding for those who manage to get there. And they'll be able to pay that debt back once they start working. And it shouldn't be borne by those who are currently in practice. So I'm not sure we're going to be able to solve that debate today. I just can tell you that's what I've heard from a number of my colleagues. Okay, any other questions? Yes.
Not sure if you can answer this, but do you expect there to be institutionally from law school to law school differences in terms of one option versus another?
I mean, I'm not sure. Everyone is doing this a little bit differently. I think at your law school, you've got a committee that has some faculty representation, some student representation. I know you have the Law Student Society. We're always very interested in what the Law Student Society has to say. I should say, by the way, that anybody who wants to respond to our consultation, you can write in on your own. You don't have to wait for your organization to do it. You can send in a letter or whatever, you know, a submission. But we read all of the submissions very carefully, including the submissions from the various organizations. And if we get any from any law schools, as we have in the past, you know, we'll obviously review those carefully as well.
And for your information, just to reiterate that, Queens does have a committee. I'm on it. So is Professor Kofeld and 2 other students, I think Lucy as well.
I don't actually know.
But we're basically, that's why I'm here to listen to you guys, and we will collectively respond and provide feedback to the Law Society. So your views matter.
Yeah. And maybe right now, then, because you guys are still here, we'll start doing the poll. If you have any questions, I'm sure anytime you can ask them. But this is sort of part of that feedback process that we're doing, and that'll go towards consultation. So it's on poll everywhere, which I think we usually have. Oops, hang on. Okay, so I guess, cool, people have already voted for this. If you haven't, you can put in your answers here. Right. Okay, and then the next question I'm going to move on. Maybe
I guess I don't get to contribute, eh?
I mean, you can, I think, if you text at the
It's too bad they don't have 1984 in there.
It is rather Orwellian, isn't it?
There's the other option. Okay, if everyone's ready, I'm just going to move to the next slide. So this one asks just for a ranking order of the options that you prefer. Has everyone had a chance to vote? Okay, I'm going to move on to the next question. So this one asks your main concerns with the current model, and you can rank your order of different problems as well. And yeah, we came up with sort of the answers for this before we had this discussion and town hall today. So if you have any other concerns, feel free to throw others, or also I'm sure you can address with any of us, Professor Smith or Peter or myself.
Just one small question. Thank you, bud. That was wonderful. If the cost of the LPP is borne only by those who actually partake in it, it would just skyrocket.